Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. All right, ladies and gentlemen, the issue of birthright citizenship is back in front of the court. The issue of birthright citizenship is back in front of the court. It has been before the court already since Trump has been in office, but it's back there now. Now, the court has not fully considered the issue of birthright citizenship since 1898. When it decided that people born in the United States are citizens, provided their parents are not diplomats or aliens of a hostile nation. So just those two requirements pursuant to the 14th Amendment, the court said, are all that's needed for a person who is born in this country to be a U.S. citizen. Again, so long as their parents are not aliens of a hostile nation, or their parents are not diplomats. If they meet those two requirements, they are automatically citizens. Hey, family, do you believe in the work we're doing? Does our content speak to you? Do you appreciate our in-depth legal analysis and political commentary from an African-American perspective? Do you believe it matters to our community? Then don't just watch from the sidelines. Please click that membership button and become a member of the 2% Club today. That's right, we need just 2% of our subscribers to become channel members. For just $4.99 a month, that's less than 20 cents a day, you'll help us keep creating powerful content that defends our democracy, demands justice, and develops a strong African-American community. But if you want more, at $9.99 a month, which is only 33 cents a day, you'll get access to exclusive members-only live streams, bonus content, and behind-the-scenes updates. And for just $14.99 a month, which is under 50 cents a day, our top-tier members get access to live Zone calls, strategy sessions, and a direct voice in shaping this movement. We're not just building a YouTube channel. Folks, we're building a movement based on righteousness and justice, just what our community needs in a time of disinformation and division. So if you believe in what we're doing, click the membership button and join now. Become a member of the 2% Club today. Let's build something powerful together. Now, the Trump administration has made an issue out of the clause in the 14th Amendment, which says not only born in this country, but subject to the jurisdiction of the United States. And that's precisely what the court decided in the Wong Kim Art case when it said children born in this country whose parents are not aliens of a hostile nation or the parents are not diplomats, then those children are subject to the jurisdiction of the United States of America. So that makes them citizens. All right, that is what precedent holds. Now, recently, the Trump administration asked the court to reconsider all of that. All right, up to this point, Trump has only asked the court to decide if federal judges can issue universal or nationwide injunctions to block his birthright citizenship executive order. And SCOTUS said, no, federal judges cannot issue universal or nationwide injunctions except pursuant to a class action lawsuit. All right. So Trump likely has not asked the court to consider the merits of this case because precedent, again, is really clear. Case law is very, very clear, as I explained above. I mean, that precedent is over 125 years, 1898. That is old precedent. And the precedent that the court used back in 1898 goes back 300 or 400 years into English common law. So that is likely why the Trump administration has not been bugging SCOTUS about agreeing with their interpretation of the 14th Amendment, the Citizenship Clause. Because again, typically SCOTUS will follow precedents. Not always. And sometimes they need to overlook precedent and rule in a different way. All right. For example, the Dred Scott case. Thank God they did not hold to precedents in that instance, as well as the separate but equal Plessy v. Ferguson case. Thank God they didn't hold to precedents in that case. All right. And instead issued the Brown versus Board of Education case. And I could give you so many other examples. And we also now have to basically say that the Supreme Court is strongly signaling that they're not going to follow precedents, perhaps in the birthright citizenship case, based on something Clarence Thomas recently said. He said that precedent is not the gospel. Precedent is not the gospel. In other words, we're not beholden to precedent as if it was the gospel. So again, he's signaling very strong that some changes are likely on the way regarding precedent. Now, I don't know what that means, but just given how many victories SCOTUS has given Trump since he's been back in office, one can safely assume that Thomas is talking about the birthright citizenship case. And I have already predicted that it is most likely going to be changed. In other words, SCOTUS is most likely going to change its interpretation of when a child born here is a citizen. I think what they're going to probably do is say that children born here of parents who are undocumented are not citizens of the United States. Now, I don't know that to be the case, but I suspect that that's what's going to happen. All right. I could be completely wrong. But I just know it's not coincidental that Thomas said that precedent is not the gospel shortly after Trump asked the court to end birthright citizenship. All right. Now, so what has happened is Trump filed an executive order and it reinterpreted what birthright citizenship is. And so now he is asking the court to rule that his interpretation pursuant to his executive order is correct. So he's asking the court to overlook the precedent set by the Wong Kim Ark case. All right. So that's what he's asking for. And again, I think that it is at least possible, maybe even probable. All right. Now, with that in mind, let's look now at what he actually said in his executive order, at least the pertinent parts of it. All right. So Section 1, the purpose. The privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Even the 14th Amendment is pretty clear. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott v. Sanford, which interpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. Okay. Then the executive order goes on to say, and by the way, I agree with that. The Dred Scott case was horrible. It said that we were not citizens. We had no rights that whites had, were obligated to respect, to honor. And so the 14th Amendment was added after the Civil War, after slavery ended, was added to repudiate, just as the executive order says, the Dred Scott decision. But I don't agree with what this is getting ready to say. All right. So watch this. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. That is true. A person must be born here and subject to the United States jurisdiction. But the court already said that a person is subject to the jurisdiction of the United States of America who was born here, so long as their parents are not aliens or were not aliens of a hostile nation, or their parents weren't diplomats. And they said so long as those two situations are not in play for a person who's born in this country, then that person is a citizen. Anyway, this goes on to say the 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States of America at birth, 8 U.S.C. 1401, generally mirroring the 14th Amendment's text. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of United States citizenship does not automatically extend to persons born in the United States, number one, when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. That is not what the Wong Kim Ark case says. They created that, put that in this executive order, but that is not consistent with the law, with precedent. Or number two, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of the Visa Waiver Program or visiting on a student, work, or tourist visa, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. So they're saying if a person is born in this country to a mother who is either undocumented or is temporarily in the country for, let's say, a work visa or just temporarily across the border and give birth to a child, then that child's not a citizen. Now, the law does not say that. This executive order cannot change what the 14th Amendment says. So the law does not say that. But that is the purpose now of Trump asking the Supreme Court to essentially agree with his executive order. And like I said already, there is a good chance. I won't say good. There is a chance that they will agree with Trump's interpretation of the 14th Amendment. Now, based on his interpretation, Section 2 of his executive order sets out this policy. It says, it is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to persons, number one, when that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or when that person's mother's presence in the United States was lawful but temporary and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. So he made that the policy of the United States, although it was contradictory, in violation of the United States Constitution as interpreted by the United States Supreme Court in the Wong Kim Ark case. Yet federal agents were, or federal agencies were absolutely duty bound to follow this executive order. It didn't change the 14th Amendment. It didn't change what birthright citizenship still is in this country, but he issued this executive order, and certain agencies would have to abide by it, federal agencies. And that's why plaintiffs affected by this executive order filed suit against the Trump administration, and federal judges issued universal injunctions. All right. And it was at that point that the Trump administration then filed an emergency application, getting the case on what's called the shadow docket, okay, the emergency docket. And that's when they said, court, would you tell the lower court judges that they cannot issue these universal nationwide injunctions? And the court agreed, with the exception of class action lawsuits. All right. And then they kicked it back down to the lower court. Since then, a lower court has issued another universal injunction because the plaintiffs filed a class action lawsuit. So now we're at the point where the court is going to hear birthright citizenship based on the merits, not based on some ancillary issue like universal injunctions, but on the actual merit of the case. All right. That is whether or not Trump's executive order is correct in the court's opinion. All right. So we're looking forward to see what the court rules, because there is a really good chance, I keep saying that, there's at least a chance that SCOTUS will rule in Trump's favor, just given the pattern that we've seen over the past 8 months or so, however long Trump has been back in office. So we got to wait. We got to see. Clarence Thomas has indicated that they're not beholden to or bound by precedent, because precedents are not gospel. All right. So that's a strong indication of where this is going. Also, there is a case that's going to be decided by SCOTUS regarding Section 2 of the Voting Rights Act. We got to keep our eye on that case as well. And then there is a case, too, that may get to SCOTUS regarding Trump's tariffs. And it's really, really, really big as well. All right, so we got to keep our eye on what SCOTUS is doing. This birthright citizenship case, this voting rights case, Section 2 of the Voting Rights Act, this tariffs case, and others are really important. But those are at the top of the food chain in terms of them having a profound impact on our nation. All right, so I am Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. And as always, stay woke.